As you know, each side will have 15 minutes, and the appellants may reserve up to 5 minutes for rebuttal. So if you wish to reserve 5 minutes or whatever, please let me know before you begin, and I will try to keep my head in the game on this computer and give you the right amount of time. You may proceed when you are ready.
Please the court, my name is Barry Eckstein, and I represent Doris Pippert, the appellant in this case. This case is interesting.
Do you wish to reserve any time?
5 minutes, please, ma'am. This case is interesting in that, I was listening to the other attorney arguing the criminal case. There's actually a video of this particular event, which I think the court probably has reviewed up to now. So how this occurred and exactly the manner in which it occurred is on video. Doris Pippert was pulling out of a Giant Eagle parking lot on December 14, 2013. It was a snowy day, wet outside.
It was not snowing at the time.
It was not snowing at the time. Her foot inadvertently slipped off the gas pedal, on the brake pedal onto the gas pedal as she was backing out and bumped into, ran into the pedestrian walking behind her. Doris decided not to try the case and her plead no contest to the charge. The initial sentence of the court was that Doris Pippert would have to retake the driving test at the end of her sentence period for the license suspension, which was the maximum allowed by law, 2 years. The court went ahead and also fined her $750. They ordered her to be on community control and sentence her to 30 days in jail, fined her $750, as they said.
And the jail time was suspended.
The jail time was suspended upon compliance with community control sanctions. The trial court's initial entry on the case, or sentence on the case, we believe was void because it contained provisions that are not sanctioned by the law. In other words, retaking the driving test. Appropriate motion was filed, and there was on July 25th of 2015 a hearing on the motion to vacate the original sentence and to allow Doris to withdraw her no contest plea if the sentence was in fact vacated. At that particular time, the trial court basically withdrew the provision of the original sentence requiring Doris to retake the driving test at the end of her license suspension and imposed exactly the same penalties as it had originally. With respect to the request to allow Doris to vacate her initial plea, withdraw her plea, the trial court really didn't conduct any type of a hearing about that. As a matter of fact, the trial judge resentenced her before even addressing the second prong of the motion to have her plea vacated, and basically said it was denied. We believe that that was an abuse of discretion. The case law, the Supreme Court has decided that when a plea is void because it includes, when the sentence is void because it includes provisions that are not sanctioned by statute, the sentence is void, and in that situation, when a person wants to withdraw a formal plea, it should be addressed by the trial court as a withdrawal of a plea before sentence. And I don't believe the trial court did that in this particular case. The transcript bears that out. Transcript on page, this is the transcript for the July 25th, 2014 hearing. The transcript at pages 4 and 5 clearly established that the trial court resentenced Doris, and then at my request about the second prong of the plea, so yeah, that's denied without further ado. The other.
Let's assume, counsel, that the trial court should have considered the motion for withdrawal as a pre-sentence
Correct.
motion. Your client is not excused from them demonstrating the other factors as to why the plea should be withdrawn. In other words, is there anything that we're going to find in the record that would show that the plea was not knowing, intelligent, and voluntary at the time that it was given?
There's nothing in the record. However, I would point out that the trial court did not allow us to proceed in that manner, to present evidence or testimony, which I believe we're entitled to do in that type of situation. I think there's a drastic difference between a plea that is a request for a plea to be withdrawn prior to sentence, and then a request for a plea to be withdrawn after sentence. And this was prior to sentencing because the original sentence was void. And with respect to the original sentence, Your Honors, I believe that the trial court lost its way and abused its discretion. The legislature has fashioned penalties for these types of crimes. This was a second-degree misdemeanor, vehicular manslaughter case. And the scope of penalties that the legislature has invoked in this type of thing is a minimum of a 2-month driver's license suspension. No fine is mandatory. And there's certainly no jail time mandatory. Now, in this particular case, we have a 78-year-old woman who was in a terrible, tragic situation, which we all saw on video, who was sentenced to the maximum allowed by statute for this type of an offense, a 2-year driver's license suspension, no limited driving privileges. She was fined the maximum amount allocated by statute, which is $750. I would think that those kinds of sanctions are for people that have either a bad driving record or the facts and circumstances of the event warrant that. The facts and circumstances of this event did not warrant that type of sentence.
What was the jail time imposed?
The jail time was 30 days, but it was suspended upon her compliance with the other provisions of the sentence.
And that was certainly not the maximum.
That was not the maximum. 90 days would be the maximum. But I would think that, I wouldn't think any judge would put a 70-year-old lady in prison on this type of thing. We all have, I don't know if any of your judges have been municipal court judges, I assume maybe 1 or 2 you have, but my experience in these vehicular manslaughter cases is typically there isn't a 2-year driver's license suspension or a $750 fine on these cases unless there's some overriding circumstances that warrant that. And I think if you look at the transcript, the sentencing transcript from the July 9th hearing, you'll find that what the trial judge did, in my opinion, is that he just imposed the sentence that was requested by the victim, Mr. McBride's heirs. Mr. McBride's daughter requested the court to revoke Mrs. Pippert's driver's license for 2 years and to order her to retest, to take the driver's license examination before her driver's license can be reissued. And that's exactly what he did. And that's, you know, I believe that in that respect and in the sentence in a whole, the court lost its way. It doesn't comply with the misdemeanor sentencing guidelines as set up by statute. None of the guidelines that the court is supposed to review with respect to misdemeanor sentences apply in this case. Does the defendant have a prior criminal history? No. Is the defendant a risk to society? No. Is it likely that the defendant will be recidivist and commit this crime or other crimes in the future? No. None of those factors apply in this case. None. The only thing that applies in this case is a terrible tragedy occurred. It was a misfortune. I believe even the trial judge says, you know, it could have been any of us backing out. And it could have been. It could have been any one of us. It's not a crime where a person went to a stop sign, failed to yield right away, or did some other type of crime. This was on private property, not on a street. It was a terrible event, but it was just that. It was a tragic event, an accident.
May it please the court, my name is Frank Carlson. I was the prosecutor in this case. I'm now the assistant law director for the city of Amherst. The argument of the defendant in this case is somewhat puzzling to me. The standard is, even on a pre-sentence plea, the standard on review is an abuse of discretion standard, as this court is aware. In this case, we had a motion filed to set aside the plea. There was a single basis set forth in the motion, and that basis was that the plea was, or the sentence was unlawful because the sentence exceeded the court's statutory authority in one respect. And that one respect was that the trial court required that the defendant retest in order to, as a condition of her monitored time. I don't know, first of all, whether or not the sentence of the court was void. And I would bring to the court's attention, and I didn't do this in my brief, but language in section 2929.25 C2, which talks about conditions of community control. And that's where this retesting requirement was found. And that section says, the sentencing court shall require as a condition of any community control sanction that the offender abide by the law and not leave the state without permission of the court or the offender's probation officer in the interests of doing justice, rehabilitating the offender, and ensuring the offender's good behavior. The court may impose additional requirements on the offender. So in this case, the court essentially said, as a condition of your monitored time, we want you to retest before you establish your driving privileges again. I think it's certainly an argument can be made that the court had that discretion under that section of the revised code.
Well, it certainly, I think, may put opposing counsel at a disadvantage to argue that but wasn't agreed. But I think it will be up to our chief judge here to determine whether or not to permit time for a response.
Okay. Thank you very much for that. Let's concede, though, that the imposition of the retesting requirement was outside of the court's jurisdiction. Does that necessarily mean that the trial court, in doing what it did, abused its discretion, essentially by denying the motion to vacate the plea? So what the trial court did was, said, we're going to have a hearing on July the 25th. I've considered Mr. Eckstein's motion, and I've decided that Mr. Eckstein's motion, in one respect, is well taken. So I'm going to not require that she retest, but in other respects, I'm going to maintain the judgment entry of conviction as it was. And the sequence was essentially, yes, that in doing so, he was implicitly, if not expressly, denying the motion to set aside the plea. If you read the transcript of the July the 25th hearing, he did give Mr. Eckstein an opportunity to say or to proffer or to make argument in any other respect that he wished to make on that occasion.
You say he did or did
He did. So I think if we look at the transcript at page 5, the trial court did say, so let me backtrack and give you the opportunity to comment on whatever you'd like to comment on. And at this time, Mr. Eckstein's response was essentially to make arguments that the sentence was unfair to his defendant for the reason that he's already has expressed in court today. Again, that reason doesn't get to, it seems to me, those factors that would justify the setting aside the plea, even under a liberal standard. So to argue that the trial court abused its discretion by granting the motion in part but denying it after giving him the opportunity to express himself, I think is misplaced. These cases are difficult cases in my experience as a prosecutor. You have an offense which in and of itself is something that all of us may do or may have done in our lifetime, which results in a catastrophic result. And that catastrophic result is the death of someone. And in my experience, the sentencing in these cases becomes very difficult. On the one hand, Mr. Eckstein says, well, a woman with her driving record should not have any substantial consequences at all. The family of the victim certainly felt differently, and they expressed that at the court hearing. So the trial judge is always in this uncomfortable position of having to weigh the badness of the conduct against the huge consequences to the family that is left bereaved as a result of the death of somebody. And as Justice Moore has pointed out, you know, we had a situation here where where the defendant was not given the maximum jail sentence. In fact, the 30 days was given as opposed to 90 days. That jail sentence was suspended. The defendant was given a 2-year driving suspension without work privileges. I understand that a person of her age, this constitutes a significant inconvenience to her, but I would ask the court to consider the implications and the consequences to the family of the victim as well. And to say that in suspending a portion of a possible jail sentence and in imposing a maximum fine and a maximum suspension, that the court had somehow abused its discretion. If the court were to take that position, it would seem to me that you're really kind of limiting trial courts in the kinds of sentencing decisions that they can make in a way that may be unreasonable. So for those reasons, I would ask this court to sustain the actions of the trial court and confirm the conviction. Thank you.
I have one question. There were no driving privileges aboard,
Yes.
under no emergency or no flexibility on that.
Yes, that is true.
All right, thank you.
Please support Mr. Carlson's last comments regarding tying the judge's hands, taking away his discretion. I think that there's statutes that require a court before sentencing an individual to review the sentencing guidelines. And our contention that the trial judge lost his way is that when you review the statutory sentencing guidelines for a misdemeanor, Doris Pippert doesn't qualify to have the sentence that she had. I mean, the discretion of the trial court is to sentence a person when considering the sentencing guidelines, and I think that the trial judge lost his way in doing that with Doris Pippert. With regard to Mr. Carlson's comment that we were given an opportunity to raise the issue of whether or not the plea should be vacated and present grounds for that at the July 25th hearing, the trial transcript, and I'll quote it, is, this is the court speaking, other than that, the court,
What page?
page 5, Your Honors. At the first full paragraph, other than that, the court is comfortable with the balance of the sentence is fair, is just, follows the law, is a sentence that considers the defendant's background, the defendant's experience, the circumstances of the accident, the input of the victims, the statutory law, the case law that applied to this offense. So based upon that, the court would reimpose the sentence in that fashion today. That's what he says. Then he says, now, I didn't give you an opportunity to say anything before I said that. Let me backtrack and give you the opportunity to comment on whatever you'd like to. And then I said, well, I gather from the court's comments, Your Honor, that the second prong of the motion that was filed is denied, and that was to vacate the plea. The court, I'll get to that in a second, but you're right, that the motion to withdraw the plea of no contest is denied. So he sentenced her before he even considered, at least on the record, whether or not Doris had the opportunity to raise that issue in terms of an actual merits hearing. The other thing about this case that I think is at least troubling to me is that, as the court knows, this sentence was on July 25th, 2014. Doris Pippert had a 2-year driver's license suspension. Now we're in, at the end of September, middle of September, end of September of 2015, leaving her less than a year left on the driver's license suspension. The trial court denied a request to stay this sentence, and so did this court. So as a result, we find that this woman has basically served most of her sentence, even before this court has a chance to rule on those issues. And I don't know, but going forward, maybe the court ought to consider these misdemeanor cases a little bit differently than felony cases where someone's in jail, because these sentences become moot. I mean, the appeals become moot after a while. There's not further relief granted pretty quickly. And as I said, this court denied the motion to stay as well. And we would like, if the court rules in Doris's favor, we would not like the case to be sent back to the trial court. All we would like is this court to impose a sentence in this case that would allow Doris to have her driver's license back as soon as possible, because we understand that the sense of vacating the plea at this point, since she's already done almost the entire sentence, wouldn't serve her any real purpose other than the driver's license aspect. Thank you.
Thank you. We will take the case under advisement and send you a copy of our written decision when it is issued, and you may always find it simultaneously on the court's webpage. Thank you. Have a good day.